Chief Counsel of the Foundation's Legal Studies Division. For those of you who are not familiar with the Foundation, we're in our 41st year of free enterprise advocacy and education through the filing of amicus briefs and original litigation, through the participation in regulatory proceedings, through publications and programs such as this one, as well as other communication devices like our blog and other social media devices. We're pleased to be addressing an issue today that certainly delves into one of the most interesting and enigmatic topics that we focused on all year. Cryptocurrency is exciting and new, and for those of you who are old enough to remember, I'm sorry if you now have the Love Boat theme on your mind. And by its very nature, averse to central control. And yet, for the currency and its uses to be accepted and successful, pleas are being issued from many corners that long-established government regulatory bodies become involved in setting clear legal standards. And certainly when calls like that go out, the competitive and creative juices of government agencies and officials really begin to flow, resulting in activity on multiple fronts, both at the federal and state levels. We're pleased to have with us today three gentlemen who are right in the middle of these legal policy developments and debates. They're going to provide you with some guidance on how governments are trying to get their hands around this, with a focus on the use of cryptocurrency for so-called initial coin offerings. We've asked Alan Cohen to act as moderator of sorts for the program, so let me introduce him. Alan is of counsel at Steptoe & Johnson in the firm's Washington, D.C. office. Before joining the firm, he served in senior policy positions at the U.S. Department of Homeland Security for almost a decade, most recently as the Assistant Secretary for Strategy, Planning, Analysis, and Risk, and second in charge overall at the DHS Office of Policy. He's also counsel to the Blockchain Alliance, a public-private forum established by a broad coalition of companies and organizations to help combat criminal activity on the blockchain. Alan, if you could get us started.
Great. Thank you, Glenn. And as I said, I'm the co-chair of the blockchain and cryptocurrency practice at Steptoe & Johnson. And what I thought we would do to start is to, thank you very much, first introduce our panelists today. We'll each do a little presentation, and then we'll ask some questions to further flesh out some of the discussions. So Daniel Alter is partner with Murphy & McGonigal in the firm's New York office. But before that, he served as General Counsel and Chief Compliance Officer for the first New York State Chartered Trust Company, providing blockchain systems for post-trade settlement and custody services, and was the first General Counsel for the New York State Department of Financial Services, and Senior Advisor and Special Counsel to New York State Attorney General, as well as an Assistant United States Attorney. New York Department of Financial Services is, of course, one of the first states and one of the most aggressive states to issue regulations in this area in terms of the bit license regulations, and I'm sure that we'll talk about those and other state-level regulations today. And also Scott Kimple is a partner with Hunton Andrews Kurth in the firm's Washington, D.C. office, and before joining the firm, he served on the executive staff of the Securities and Exchange Commission as counsel to Commissioner Troy Paradis from 2008 to 2012. And in that role, he served as the Commissioner's senior staff, as well as liaison to the external constituencies, including issuers and other SEC registrants, and he leads his firm's working group on blockchain and distributed ledger technology and edits its blockchain legal resources blog, a similar blog to ours. So what I thought we'd do first is just give a little bit of background on how we got here. We'll presuppose a basic knowledge of cryptocurrency, what it is, and crypto tokens, what they are. And what's important to see is kind of the progression from the launch of Bitcoin to how we got to where we are today. So really, all of this starts with Bitcoin, with the Satoshi Nakamoto white paper issued in 2008 and the launch of the Bitcoin blockchain in early 2009. This launch was the first cryptocurrency, in essence, the first cryptographic exchange of value that was secured rather than by a central intermediary by cryptographic process. And so what this allowed is a distributed, decentralized, peer-to-peer kind of exchange of value, and the ability to launch tokens that represented different things in a distributed, decentralized environment using blockchain technology, the ability to hold multiple identical ledgers simultaneously across a range of different computers. And so this system worked well among the cryptographers and other kind of enthusiasts who were early adopters of the technology, but was largely unknown to others at that time. It became more known to folks in law enforcement at that time and others. But an interesting initiative started in the 2013 timeframe when a number of Bitcoin enthusiasts said, the Bitcoin blockchain Bitcoin is a great initiative, but there are some problems with it. Number one, it's not so fast. You can't process transactions at speed through it, and it's difficult to program it. What if we rewrote the Bitcoin blockchain, but just made it easier to program in business logic? Simple if-then statements that will allow you to have smart contracts that are administered in this decentralized way. And so what this group of people envisioned was a new blockchain called Ethereum. But rather than simply begin mining out Ethereum coins, developing the platform and mining out Ethereum's native coins, which are called Ether, instead they pre-sold a certain amount of Ether before the platform was built in order to build the platform. So in the summer of 2014, the founders of Ethereum sold about $11 million worth of Ether in order to fund the development of the platform. And that resulted 1 year later, in the summer of 2015, with the successful launch of the Ethereum platform, which now has a number of different third-party applications that work on top of it. It has a decentralized governance structure. But it began with the pre-sale of tokens in order to fund its development. In 2016, a group of developers in Germany created a company called Slockit, which was meant to use the Ethereum blockchain to develop a smart lock technology. And they were frustrated by the lack of ease of availability to capital in order to fund projects like theirs. And so what they did was they created, in essence, a investment fund. And they did it on the blockchain. And what they were going to do was they were going to sell tokens that enabled individuals to contribute Ether. And in exchange for the Ether, they received the right to vote on projects, yes or no, the group should do it. And they would share in the profits when that investment fund realized profits from its investment in different initiatives. And what was really unique about it was there were no people involved in this initiative. It was simply protocol. This was called the DAO, the Decentralized Autonomous Organization. And in May of 2016, the folks who wrote the DAO code offered their tokens for sale. They intended to raise $500,000 worth of Ether. And they ended up raising almost $50 million worth of Ether in 28 days, which showed the potential of this technology to raise enormous amounts of funds in a decentralized manner using just virtual currency exchanges or direct sales of tokens to individuals. Unfortunately, the DAO code included a latent flaw that allowed for individuals to recursively draw out their money and resulted in a hack or unauthorized withdrawal of almost $36 million worth of Ether, which sunk the platform. But sitting behind that were questions about, was this a permissible sale of tokens or was this something else? Was this actually the sale of an investment contract? Was this actually something regulated by securities regulators? But the combination of Ethereum's pre-sale and the potential to sell tokens to fund the development of platforms, combined with the amount of money that the DAO was able to raise in just a short period of time, led to an explosion in the pre-sale of tokens in order to fund the development of platforms. And in 2017, according to some estimates, some $5.6 billion worth of tokens were sold, largely in pre-sales, in order to fund the development of platforms that were intended to reach their maturity. Now, it's often said that this entire area went unregulated and that no regulations reach any of this activity, but that's not exactly true. In fact, there are a number of different overlapping and interlocking regulatory structures that apply, but to different degrees of clarity. First, currency regulations, things like know your customer requirements, anti-money laundering requirements under the Federal Bank Secrecy Act, sanctions compliance requirements, and state money transmitter regulations, and specific licenses, specialized licenses that are required at different state levels. Second is securities law, whether that's the Securities Act, Securities Exchange Act governing exchanges, Investment Company Act, and Investment Advisors Act governing investment advisors and funds, and state laws and regulations. Commodities laws, treating these crypto tokens as commodities, and regulating the cryptocurrency exchanges on which many of these tokens were either initially sold or for which there's a secondary market. And of course, taxation. First, we're going to focus on securities laws and talk about the implications of Securities and Exchange Commission regulations, how they apply and where the ambiguities still sit. And then we're going to broaden out to a broader range of activities at the state level that reach a number of these different topics. So with that introduction, let me turn over to Scott to continue our program.
Thanks very much, and I think that was a great overview of the subject. I, as someone who's been practicing securities law for a long time and for my entire career, watched the development of this marketplace with great interest. Not only because of its innovative nature and the entrepreneurial spirit that accompanied it, but also because I and others in the securities bar started scratching our heads and saying, why aren't these things being regulated as securities? Because the fundamental rule under securities law, whether it's federal law or state law, is every offering of a security has to be either registered with the regulator, the SEC at the federal level, or at the states, whoever the designated regulated there is, or there has to be an exemption from those registration requirements. And the exemptions that are available tend to only apply to offerings made on a limited basis, small groups of investors who usually have some level of financial sophistication. That's different than the model of a lot of the different cryptocurrencies and tokens that were being offered. These were offerings that were made to very large groups of people, really no limits on investor accreditation. These were true retail investors, and very little disclosure was being made about the investment opportunity. Usually what you had, if you had it at all, was a white paper, which was basically a technical document. Now, sometimes they were longer and had more about the business proposition, but usually it was a technical paper written by folks who understood code for other folks who understood code. Very little, if any, discussion about risks associated with investing in the business, how the business might grow, what its prospects are, what its historical record, if it had any, was. And these are all things that start sounding alarms for securities lawyers, because the Supreme Court took up this issue many, many years ago, back in the 1940s. We saw the slide just a few moments ago with the 4 different federal securities statutes. They all have a slightly different version of what a security is. The Investment Company Act in particular has one that's a little bit broader than the other 3, but by and large the courts have said that they should be read holistically and interpreted consistently. And so when you read through the long litany of instruments that are considered securities for purposes of federal law, and state law tracks this for the most part as well, you have traditional things like stocks and bonds. Everybody understands that those are securities. But there's also this elusive concept of an investment contract. And what's an investment contract is something that has puzzled, I think, observers and securities lawyers ever since the 1930s when those statutes were initially adopted. Well, believe it or not, the Supreme Court took this up in 1946. So what we're talking about is a 1946 case being applied 70 years later still to determine whether a financial instrument that doesn't neatly fall into one of the other categories like a stock or a bond, whether it's a security. And the case involved, it was a case called SEC against Howey. And Howey owned a series of companies that owned orange groves throughout the state of Florida. In the winter, people from the Northeast would come down and vacation. They'd stay in hotels that adjoined a lot of these orange groves. And Howey had a great idea. I can try and raise money to increase my acreage and increase the amount of oranges that I'm processing through my orange juice machines by finding some outside investors. And the way he did is he approached folks, many of them who had stayed in the hotels, few if any of them were actual Florida residents, and said, I've got a great idea. You like the state, I like the state, we all want to grow oranges. Let me sell you some orange acreage, sell you some of these orange groves. Now you live up in New York, you live up in Boston, you're probably not going to be able to farm them yourself. So let me also take care of that for you. You buy the orange groves, and then I'll offer you this management contract. And under the management contract, I'll run the growth process, we'll tend to the orchards, and when the oranges are ready for harvest, we'll harvest them, we'll process them into juice or whatever else, and you'll get an annual return on that investment. Sounds like a great deal. As often happens in these kinds of transactions, subsequently someone was dissatisfied, talked to a lawyer, and decided there may be grounds to sue. And when the lower courts looked at this, they said, why are we even talking about the securities laws? We're talking about orange groves. That's real estate. Real estate's not a security. Well, the Supreme Court said, you know, if it were just an orange grove, you'd probably be right. But you have this management contract. And when you couple them together, they created kind of a holistic proposition. And when you look at kind of the economic realities of this, what these investors were investing in was not orange groves. They weren't looking to buy land and hold it for the long term. What they were looking to do was get that annual return when the oranges were harvested and they were processed, and they would get a royalty check of some kind. So when you put those together, that starts looking more like an investment opportunity. And so the court laid out a four-part test. It's still the test we use today with some minor variation across the circuits to analyze whether any kind of financial investment opportunity is an investment contract and thus a security under the federal securities laws. And the four-part test is that you have to have an investment of money in a common enterprise with an expectation of profit solely from the efforts of others. And really, that solely from the efforts of others prong is the one that becomes a sticking point for most of these kinds of opportunities. Because it's usually pretty obvious that you've got money invested, and people don't just invest money hoping that it doesn't have any kind of return. And here, it was sort of the classic example. None of the people who bought these orange groves were going to be the ones who actually managed them or grew the crops or harvested them. They were going to depend on third parties to do that. So really, the only way they were going to get any kind of economic return was if other people, solely from the efforts of others, generated that return from them. Another classic example of a security is a limited partnership interest. You put your money in, usually there's an expectation that over time you'll get some economic return on that, but you have very limited, if any, management rights. And so as the token economy started to explode 4 or 5 years ago, again, people started to look at this thing, well, why aren't these securities? And some of the folks who started looking at it were, lo and behold, employees of the SEC or employees of the states. And the states, again, tend to look to the Howey test or similar statutes or similar cases under state law to make that analysis. And as often happens when you have an emerging technology or an emerging trend, the SEC kind of approaches it in steps. Rulemaking is a very lengthy process. Congress hasn't acted still on this issue. So the SEC starts drawing on its other powers. People start giving speeches. You see senior staff members, you see commissioners saying things like, hey guys, these look a lot like securities. Does anybody remember that Howey test? I can remember when I was on the SEC 10 years ago, we had several cases where there were sort of new and novel financial instruments that had been invented. And the question was, is this a security? And under Howey or some of the other tests, usually the conclusion is it is. So to see folks treating this as not securities, I think aroused enough concern at the SEC that the first thing they did is they hit the speed circuit. And sometimes that's enough. A few well-placed speeches, the market gets the message, they respond. Didn't really have that here. The market, if anything, as these speeches were going on, accelerated and more activity started happening. So the SEC then decided, well, what's the next tool in our toolbox? We can go out and sue a bunch of these people, but that's not really going to teach anybody anything. And that maybe is a bridge too far. Now, sometimes they do use enforcement to set policy, but here they used kind of a middle measure. There's a provision under the Securities Exchange Act, Section 21A, which authorizes the SEC to conduct investigations, but also to issue reports on those investigations. And from time to time over the years, the SEC has used that provision to announce policy. Look, we investigated this set of facts. We're not actually going to seek a sanction against this particular defendant, but the world should be on notice that if you do the same thing in the future, we are going to come after you. And that's exactly what they did with the Dow. And so in July of 2017, the SEC issued one of these reports of investigation or Section 21A reports to the securities bar that kind of went in and delved into the structure of the Dow token and applied basically the facts of that particular instrument to the Howey test. So, there's been this question, well, why doesn't Congress pass a law talking about tokens and make its status under the federal securities laws clear? I think some people would say that status is somewhat clear, although we will get into some of the gray areas, because most of these can be looked at through the lens of Howey. And again, that's exactly what the SEC did with the Dow token. They looked at the rights that the investors had. They did have some voting rights. They did have some governance rights. There were also some financial returns that came in it. And they said, look, we have an investment of money in a common enterprise with an expectation of profits. So as I alluded to earlier, it all came down to, is this arising solely from the efforts of others? And often what you want to do to try and rebut the notion that it is from the efforts of others is say, look, we gave all these management rights to holders. And if they have meaningful investment rights or control rights, then they're not really depending on third parties. They're exercising their own control. I mentioned limited partnership interests earlier because those are true passive investments. But on the other side of the coin, general partnership interests in most circuits are generally not considered to be securities because you have managerial rights as the general partner. And that, in effect, is the argument that the Dow and its promoters made was, look, all these investors had management rights. They got to vote on things. They got to vote on the investments we were going to make. They had all these rights to control. And the SEC looked at that and said, close, but no cigar, because really they weren't investing in this to have these management rights. They were investing in it because they thought that you were building something big. And the kind of rights they have are sort of akin to the rights of common shareholders in a big public company. There's not enough ability for folks to meaningfully exercise control. And the very feature that impeded that was the decentralization. It was very difficult, if not impossible, for individual holders to get together and coordinate their efforts. So the SEC determined that it was a security, and they put in a lot of language that said, look, anyone that's issuing something similar to this needs to apply this test. They also took a second out and put in some additional warning language, which was one of the features of the Dow token that also, I think, was instrumental in its conclusion it was a security, is that there's a very active secondary market. People were buying and selling these things, which indicates, again, they weren't holding it because they wanted to control or be invested in the long-term growth of the Dow. There are a lot of folks that were just simply speculating on it, and that sort of speculation is another factor that the courts often look at. And in order to speculate, of course, you need to have a secondary trading market, and there were a host of different trading platforms, and I use the term exchange loosely because none of these are registered securities exchanges, but there are places that even today you can go to buy and sell digital assets of one kind or another. And the SEC warned, they said, look, the flip side to this is if you have a security, if you're someone that's making a market in these, you're buying and selling them, you're acting like a broker or a dealer of these instruments, you got to go register as a broker-dealer or even an exchange. And so there's a lot of cautionary language about that in the report as well. So the SEC issues that report, and what happens? Well, not a whole lot. People kind of kept going, the frenzy kept building. And so the SEC brought a follow-on case against a company called Munchie. Munchie was a startup company. They had offered a token that was investing in basically their platform, which was pretty benign. It was a food review and social review platform, sort of like Yelp or something like that. And you would get one of these tokens, and it would give you certain rights, and you would be incented to sort of provide comments on restaurants and those sorts of things, and you might get more tokens for doing that. And of course, this was marketed the way every other ICO had been marketed up to that point. No real effort to screen out non-accredited or unsophisticated investors. No real meaningful disclosures about risks. Really just kind of this technical white paper and not much of that as it was. So the SEC brought a case against Munchie and said, look, you're violating this provision of the securities laws. It's called Section 5, and it says if you have a security, you have to register it with us or have a good exemption. We don't see any exemption. You haven't registered with us. You're in violation. Munchie said, mea culpa, we'll stop immediately. Don't come down on us hard. They cooperated with the investigation. So the SEC assessed relatively light penalties. But again, this is sort of a marker case that we're going to go after folks that are doing this. And the interesting thing about Munchie is that it was a standalone Section 5 case, meaning a standalone non-registration case. The SEC brings them from time to time, but usually to whet the appetite of any enforcement lawyer at the SEC, there has to be some sort of fraud. The federal anti-fraud statute is Section 10B of the Exchange Act, or Rule 10b-5. There's also similar provisions in the other securities laws. But usually you're looking not just at the technical violation of not having registered an offering, but there's also some misrepresentation or omission that was material that was made. Didn't have that in Munchie, or at least it wasn't alleged. So what happens? Well, the SEC continues with its enforcement efforts. By this time, there's all sorts of Ponzi schemes that are going on that usually involve some sort of pooled investment in Bitcoin that isn't real. You know, I would distinguish those from some of these token offerings where at least you had a real business that was trying to do something authentic, may have run afoul of some of these technical rules. But of course, the marketplace responded and said, well, part of the issue with Munchie and the DAO and some of these other instruments is that it was that solely from the efforts of others prong, and that you were really depending on it for some kind of investment return. What if we issued a token that had some utility to it? In other words, you could use it to actually buy or sell a good or a service, or do something with it other than just hold it for speculative purposes. These things are called utility tokens. A number of them have been sold. And again, they're sort of in a bit of a gray area, but maybe not so much when you look at Howey. Again, talking about SEC speeches. SEC Chairman Jay Clayton gave a speech late last year about so-called utility tokens. And he said, these things are theoretically possible, but if you're going to have offerings, and this is a quote, that incorporate features and marketing efforts that emphasize the potential for profits based on the entrepreneurial and managerial efforts of others, then you continue to have to be cognizant of Howey. And that's been one of the main hang-ups with most of these tokens that have been issued is they're really not an operational business. What it is it's the promise of some future business that we're developing. These token offerings have sort of taken the place of seed rounds or friends and family rounds that used to happen in the past, where to commercialize your product and get it out of your garage or your apartment, you go raise some money from friends and family, and you use that money to then get it to the next stage where you start commercializing it. Then you start seeking venture capital investment. I think as we saw in the Dow case, and as Alan explained, they found that process in their situation very difficult to do. So they said, well, let's bypass all that. We'll just start from scratch with selling this. And that tends to be the problem from a regulatory perspective with most of the tokens. Because what you're buying is not an operating business. You may say that there's some utility to it, but does it really have any utility if you can't use it yet? In other words, the platform may be a great idea, it may be revolutionary, but it doesn't exist yet, and it won't exist for 6 months or a year or longer. And that tends to be kind of the weak point, both when the SEC analyzes these, and also, we won't spend a lot of time talking about it, but there's been a huge wave of private litigation, which is very unusual that you have private lawsuits or even class action style lawsuits against startup companies. Usually they don't have the kind of money. But when you're talking about $50 million, $100 million, $500 million that's been raised in some of these deals, that makes it an attractive target. So we have Dow, we have Munchie, we have some speeches. Marketplace is still a little bit uncertain. And again, the SEC trots out its tried and true tool, a speech. So Bill Hinman, who is the director of the SEC's Division of Corporation Finance, they're the group that regulates most capital markets activities for capital raising, regulate public company disclosure. Hinman comes out and he gives a speech in June of this year at a big tech conference. And to everyone's surprise, he starts talking about some of these issues. And the first thing he does is he affirms for the first time really that Bitcoin is not a security. That had been sort of hinted and people had kind of thought about it, but he said affirmatively Bitcoin is not a security. Now it's always interesting anytime someone from the SEC gives a speech. Our co-panelists were joking about this before we get started. Every SEC speaker starts by saying these are my own views, they're not the agency views, I don't speak for the agency. True, technically as a matter of administrative law, but when someone like Hinman gives a speech like this, he's just not doing it as a rogue actor on some frolic or detour, but he's gotten some high level of clearance and some high level of buy-off from the right people. So he says Bitcoin's not a security. Then he says something else which is somewhat surprising. He said Ether, which Alan described earlier, is also not a security. And the reason it's not a security, why neither of these is a security, is their decentralized nature, he said, and the lack of informational asymmetries that these kinds of assets pose, which would then therefore lead to a need to have the protections of the federal securities laws. Kind of glazed over a few details and I think simplified things a little bit to make it sort of fit his model. But nonetheless, we now have an affirmative statement from someone in authority at the SEC that Bitcoin and Ether are not securities. We have the Dow report. And so people sort of, when they have to look at a new kind of crypto assets, as whether it's a security or not, it's basically a balancing test. Does it look sort of more like Bitcoin or Ether? Does it look more like the Dow token and all the stuff that Howie talked about with orange groves, et cetera? The other interesting thing that Hinman hit on was the idea that something can start life as a security and over time evolve into something that's not. So going back to this concept of utility tokens, that at some point in time there's its own intrinsic value or worth or use or purpose that it's not being held simply for investment purposes. And this has been another area where securities lawyers have spent a great deal of time debating. Can something start life as a security, particularly if it's a startup venture? And yeah, sure, it meets Howie at that point. But over time, it evolves. And let's hope that this company hits a home run. And they do develop their network. They do develop their platform, their system. These tokens then have some sort of independent value and usage that goes beyond just sort of speculation and investment. A lot of securities lawyers, and candidly, me included, were skeptical that something could evolve in that way. But Hinman opened up the door and said, actually, it's a theoretical possibility. Now, whether that's going to happen all the time or not, we don't know. But he said the analysis of whether something is a security is not static. It is not strictly inherent to the instrument. And then he went on and he gave a different couple of sets of balancing tests that you could use as rules of thumb to make these determinations. And so the debate goes on and on. I think where we ended up, though, is that the default position the SEC has on these things is that it's a security unless there's something really special about it. And you have to treat it accordingly. So continuing the evolution, someone said, well, I want to have retail participation. And it's not going to fit in one of these exemptions from registration. So I can't sell it to all these retail investors. But it's really important for me for these tokens to be held by large groups of people so that they can start being used immediately. What if I just give them away? What if I do what's called an airdrop, which is basically that. You just give them away to large groups of people, sometimes with a string on it, but sometimes not. Well, as you might expect, the SEC has an answer to that too. And it turns on what's basically known as the no-sale theory. If you can make out an argument that when you give something away that it's truly a bona fide gift, then there's no sale for federal securities law purposes. That doctrine is usually used for estate planning, transfers, those sorts of things, charitable donations. It's harder to make that argument out when you're talking about a commercial enterprise. And that's exactly what happened here. You had a company that tried to do a token offering, didn't really work out. They wanted to give the tokens away to anybody who would take them, so that's what they did. They did an airdrop. And the SEC looked at it and said, look, you didn't give these tokens away for sort of the detached, egalitarian, altruistic reasons that people give gifts. You gave it away to benefit yourself. You wanted to build your network out. And for that reason, it's not a gift. Even though it's hard to measure the value of that, there is some opportunity cost or some intrinsic value to you for having people develop your system. So that's not a gift. It's an offer or sale, has to be registered. Curiously, the SEC had one of these cases 20 years ago during the height of the dot-com boom. You had a lot of dot-com companies that were trying to develop interest in their websites and their platforms. And think of pets.com and all those guys that through the creative destruction of the marketplace no longer exist. But back then the idea was to gain traction and get your website visited. We'll give away stock to people. So what was called the free stock cases, where a number of these dot-com companies just gave away stock to large groups of people. The SEC came in and did the same sort of analysis. These aren't gifts. These are sales. I want to close with just a couple of more recent enforcement cases that I think are notable. They were brought on September 11th, my son's birthday, and of course it's an important day for all Americans. But there were a series of first-of-their-kind cases that the SEC brought. The first one, remember we talked about under Dow, if you're a broker or a dealer of a security, you have to be registered with the SEC under a separate provision. There they targeted somebody who was an unregistered broker-dealer and said this particular person was operating what they billed as an ICO superstore that solicited investors, took in money, actually made a market. Sometimes they're paid in cash, sometimes they're paid in tokens. The SEC looked at that and said, look, we have this test for a broker or a dealer. You don't have an exemption from that. You should have registered. Same day they brought a case against a hedge fund, a digital asset hedge fund, who held a large portfolio of digital securities. And there's a test under the Investment Company Act, that's one of the other organic statutes of the SEC, that says basically if more than 40% of your assets are cash or securities, then you're in the business of investing in securities. This is an issue that comes up with some public companies that are very cash rich and they go get an exemption. But typically someone that has a large portfolio of securities is in the business of investing in securities. They're what's deemed an investment company and they're required to register. This is the same statute that regulates Vanguard and Fidelity and all the other mutual funds we invest in. But it applies to anybody. If you have a portfolio of securities, that's your primary line of business, you have to register. Some other exemptions there, but they didn't apply in this case. Finally, on the same day, FINRA. FINRA is a self-regulatory organization that regulates, shares jurisdiction over broker-dealers with the SEC. as well as registered representatives, basically salesmen or other parties who work for broker-dealers. And they brought their first disciplinary action against a representative who was out selling cryptocurrencies, was not being forthright, he was making misrepresentations about them, and he was sanctioned as well. So that's a very quick overview of this subject. I've had this talk that's taken 3 hours and 4 hours for people who want to listen to it, so I ran through it really quickly. But I hope it gives you just a quick overview of what the state of the law is and how it's constantly evolving. And one of the things that you often hear is, well, the SEC should have more formal guidance, or Congress should write a law. Maybe these things will happen. It's not usually the SEC standard operating procedure to issue detailed guidance on things like this. When you have something like the Dow report, you have these speeches, you have the enforcement cases. Their perspective is an informed and educated member of the public, and particularly an informed and educated attorney, can read these things holistically, and based on that and just the general understanding of how our statute works, you should sort of know the answer. So I'm not optimistic that there'll be future guidance that's going to provide a massive exemption from these things, but we may see in the future are additional talking points that help to refine the analysis on some of these sticky issues.
Good afternoon, everybody, and thank you so much for having me here today. I think that was a wonderful introduction to the subject. I think now I'm going to try to take the subject a little broader, and given that we're coming on the 10th anniversary of Satoshi's white paper, it's actually this month, I think it's appropriate to take a 360-degree assessment of the regulatory landscape as it exists now. We have, as I said, we've had a wonderful overview of federal securities developments. I'd like to touch upon some of the issues that have evolved, again, the emphasis on evolution over time on the state level and how they've interacted with the federal regulatory bodies. Now, I think at this point, I firmly believe we are where we are as a result of where we've been. And I think it's helpful to look back over time to see how things have evolved and why we find ourselves at this juncture in a place of some ambiguity on both the federal and state level. So it's important to place things in a historical context. Beginning with the cryptocurrency regulation that FinCEN put into place in 2013, which was a very important event because it was really the first major regulator of financial transactions to have a say in crypto transactions. FinCEN put out a guidance which defined administrators and exchangers of virtual currency as money services businesses for the Bank Secrecy Act and the anti-money laundering requirements under federal law, requiring those kinds of administrators and exchangers to register as MSBs and to have certain anti-money laundering policies in place and to report when there was some suspicious activity. The FinCEN specifically excluded from those requirements users of virtual currency. So in essence, those who would buy and use it for themselves were not considered any kind of regulated entity, but those crypto exchanges that were exchanging fiat currency for then Bitcoin and the newly developing cryptocurrencies were considered regulated entities. And I would like to, for the evolutionary metaphor, call this the Triassic period of cryptocurrency regulation. And I emphasize Triassic because regulators were trying to regulate this kind of stuff. Now, with FinCEN being the prime mover in this area, some states kind of took notice and decided they were going to get into the jurisdiction, as it were. And some states started to characterize virtual currency exchanges as money transmitters, and which would require their registration under state statutes as money transmission entities. But the problem with most of the state statutes in place then, and even to this day, is that money is often defined with a direct reference to fiat currency, actual money or representations of actual money. State-level regulators didn't know what the heck virtual currency was, and the response to it was, well, these exchanges are really two-leg transactions. There is a fiat currency transaction where someone sends in cash to a middle person. That middle person turns it around and finds somebody who has virtual currency, swaps the cash for the virtual currency, and sends the virtual currency back to the original buyer. Well, insofar as that transaction involved fiat currency, state regulators were perfectly comfortable with that. They had been regulating people who were acting as intermediaries with regard to the transfer of value in cash for many, many years. And they said, okay, those folks who are engaged in virtual currency exchanges and are engaged in this type of transactional conduct, to the extent you are handling fiat currency, you are money transmitters and you must get a money transmission license. There are other states that just said, you know something, this is not within our bailiwick, this is not captured by our statute, we're staying out of this in our state, and there weren't too many of those, but there were several. You don't have to worry about registration or regulation. Now, this left a very significant hole in the regulatory tapestry that was being woven. And what is that hole? That's the whole virtual currency arm of the transaction. Bitcoin had value. People were buying it. There was no regulation for those handling or transferring Bitcoin or other cryptocurrencies in connection with the larger transaction. So for example, if the entity that was handling fiat currency lost your dollars, they would be subject to state regulation in trying to get your money back from you or be subject to penalties and enforcement for some misconduct. But to the extent that they were handling cryptocurrencies on the other side of the transaction, and that disappeared into the ether, no pun intended, there was no regulatory framework to address that problem. So along comes the New York State Department of Financial Services in and around 2014 and 15, which introduced the concept of what is now known as the bit license. Now, this was viewed, as said earlier, as a very aggressive move on a part of a regulator, because it was recognizing for the first time that cryptocurrencies were in themselves some kind of asset to be specifically recognized and regulated, and it had unique aspects that need to be addressed separate and apart from the regulatory necessities of fiat currency transfers. Now, because this was such an aggressive move, I'd like to call this the Bold-ASIC period of cryptocurrency regulation, largely because it was such a bold step. This evolutionary development is really marked by several key points. First, the bit license demanded heightened BSA AML standards and deep concern, because there was a deep concern for criminal activity in those days using cryptocurrencies. Folks might remember the Silk Road criminal case where the FBI penetrated an underground and black market drug and weapons operation and sale that was using Bitcoin as its means of value transfer. It created a great deal of notoriety at the time, and it was forefront in the mind of New York regulators when they were considering issuing a crypto regulatory scheme. The bit license also, for the first time, took into consideration a need for heightened capital requirements for money transmission-like businesses. And why is that? Because then as now, cryptocurrency was marked by enormous volatility. If you lost dollars along the way of transmitting it from person A to person B, a dollar's worth a dollar, you have a fairly solid sense of what your exposure would be. You can buy a bond or insurance to make whole the customer that you've injured. But in the course of a day or so, virtual currencies were fluctuating enormously. So there had to be a cushion within these companies that would allow for them to be solvent in the event of some financial or business catastrophe. And then there was also, of course, the heightened cybersecurity standards that the bit license imposed on those who would be virtual currency businesses. You know, in retrospect, certainly cybersecurity was of great import then. Hacking was of great concern, as it is now. But now, actually, that foresight is coming into focus even more acutely because recently I was reading about the development of quantum computers that are able to essentially break the cryptography that is really the backbone of many of these virtual currencies, allowing for evildoers to come in and disrupt the blockchains that support multiple cryptocurrencies. So cryptos and cybersecurity issues and security standards are of ultimate importance in the bit license context. Now, there are a few common elements of the Triassic and Boldastic ages, which I'd like to point out for everybody as we go along this evolutionary path. First, in both of those periods, the regulatory focus was a focus on the regulation of a business and not a market. That's to say that consumer protection in the provision of services was really the concern of regulators, to be sure that those using exchanges and transfer rails were not in jeopardy. But the focus was not so much on the integrity of the product. That is, no one was looking at what the digital asset was per se. And as a related issue, the focus back then, way back then, 3 years ago, was largely on understanding cryptocurrencies in terms of being a means of transfer value. It was not really even conceived of at that point as a long-term investment product, as we've just heard it's been speedily developing into. So come now 2016 and 2017, and I'd like to designate it the beginning of the Confucius period of the cryptocurrency evolution. Why? Because regulators are not sure what the heck they're doing. We have now a new era of digital assets that are coming to the fore, and there's a lot of ambiguity and grayness in the regulatory world. Now, the fossil record from this period contains the origins of digital tokens and ICOs. And what do we see? We see that the value of some digital assets had become tied to financial prospects of specific business enterprises. Again, we had heard about the tokens being released, they're tied to nascent but not yet operating entities, but there is a business plan per se in the entity that is going to yield, hopefully, a profit. The digital asset thus becomes a vehicle for raising capital. It hadn't been, as I tried to express before, it really hadn't been viewed that way before. It had been viewed as a means of transferring value, but here it now becomes a vehicle for generating value. And regulators start to wonder whether these assets have lost their primitive tails and have evolved into some kind of security. Well, we have the Dow and Munchie to document the evolution of those thoughts. So, per that development, in 2017 and 18, the SEC comes along and says, yes, that digital tokens are subject to the Howey test, and therefore digital tokens can be securities for federal regulatory purposes, i.e. subject to various security statutes and SEC rules. But from a regulatory perspective, this is growth on a new branch of the evolutionary tree. In addition to business supervision, the government's focus is expanding into market supervision. Again, we're not just worrying about the transfer of goods and products, but now all of a sudden this market is developing and folks are concerned about its integrity. Now, with any growth, oftentimes the branches become tangled. And even incremental regulation has unforeseen consequences. So while it is both prudent and ordinary course for federal and state regulators to take things bit by bit, again, no pun intended, and to take measured steps towards asserting jurisdiction. This kind of unforeseen consequence has raised several potential conflicts between state and federal regulation, given the overlap. So, for example, one of the issues has arisen is, do SEC-registered broker-dealers actually need money transmission licenses or bit licenses when dealing in digital tokens? When they are delivering an acquired digital asset to a customer, do they need a specialized license to do that? I've had calls from numerous clients seriously concerned about whether by delivering something they've acquired for someone, they're in violation of New York state law. Now, Only some states expressly exempt registered broker-dealers from the money transmission requirements. There are these money transmission statutes have sections that say, to the extent you are registered by the SEC or the CFTC, you don't have to worry about getting a license to send funds to and fro or act as an intermediary with regard to value. But they don't all contain them. In fact, there are quite a few that are completely silent on the issue, and there is no general federal preemption that has been asserted by the SEC as to whether or not the states have a place in regulating the transfer of digital assets. So, as a historical fact, though, states, and this has been confirmed among discussions that I've had with numerous state regulators, states have really never become involved in asserting money transmission issues, whether or not their statutes provide an exemption. They've just taken the position that if the SEC has registered an entity as a broker-dealer, their transactions are beyond their reach and actually need not raise any concern for them because those entities are being supervised by a responsible agency. But given the state's discomfort with cryptocurrencies, largely from a lack of understanding, and not to their fault, it's all quite new, it's not clear whether they'll take the same position with regard to the delivery of digital assets. That remains to be seen. Another state issue that arises goes directly to the Howey test. States across the United States have what are known as blue sky laws, which are essentially anti-fraud statutes that have to do with the registration and sale of securities within the state. And many of those states have differing definitions of what a security is. Again, those are not preempted by federal law. If some precocious or aggressive state were to decide that their statute reaches beyond Howey, and in fact they want to regulate more aggressively this concept of a utility token, that's something that could quite conceivably happen. It hasn't yet, but that issue is out there. Perhaps the most direct conflict that has come into place so far is the conflict between the OCC and state banking regulators with regard to the OCC's proposed chartering of a fintech bank. Putting aside whether or not the OCC actually has statutory authority to do that, which the states have argued they don't, such an act by the OCC would preempt with one great sweep a whole host of state consumer protection and anti-usury laws, because as a federally chartered entity, that entity is not subject to those state laws. Should the OCC do that? Is the OCC in the business of regulating banks with regard to those particular products and services that are most subject to those state laws? Again, it remains to be seen the types of businesses that the OCC intends to charter. But these questions really raise a broader question, which is, should regulation as a whole be technology agnostic? Should regulators, both on the state and federal level, begin to regulate and focus on regulating the activity and not the mechanism or medium? A lot of focus by thought leaders and regulators and academics has spent a great deal of time considering the technical aspect of cryptocurrency. Maybe that's misplaced, or at least shouldn't be something that's so heavily considered, because at the end of the day, it is really a different medium for a familiar either product or service. And that specific product or service is what brings about certain regulatory requirements and demands. It raises risks that regulators need to address. And, you know, should the proper sphere of regulatory authority really be defined according to the mission and expertise of a particular regulator, rather, again, than according to technical medium in which certain transactions are undertaken? Now, I don't want to leave folks thinking that the confusacious period, as we've called it, is necessarily an age of regulatory conflict, because I really don't think this is about survival of the fittest agency. Things are going to evolve, I suspect, far more symbiotically, and here are a few examples I think folks should think about. First, there has been tremendous cooperation between the North American Association for Securities Administrators, otherwise known as NASA, and SEC enforcement officials. SEC has done some excellent work in defining what is a security under the federal statutes. It has a tremendous amount of resources in investigating large cases and taking enforcement action against large cases, but most of the risk on common folks in the United States, on ordinary mom and pops who are buying securities and want to enter into the market, exists on the state level. And it is state regulatory enforcement efforts to close down fraud shops and close up these pump and dump schemes or outright frauds where nothing exists except for the coin, has worked tremendously well in connection with the SEC. So there is an all-out brawl going on between federal and state regulators on that. There is another issue where I think federal and state regulators can work together at this point. It's a very, very pressing issue to resolve a problem of market failure, which is causing a lot of consternation in the investment market, and that is the area of custody, the custody of digital assets. When the SEC came out, and we were talking about it earlier, and said tokens are subject to the Howey test, and therefore if you're acting as a broker-dealer, you must be registered as one, they imported at the same time all the requirements that apply to federal securities with regard to where broker-dealers and investment advisors need to custody those assets on behalf of their clients. Again, this ranges from the mom and pop to the huge institutional investors. Where do we put these things? There has been no direct guidance from the SEC on this yet, and many people who are observers of this situation say it has stymied the development of the market because people are unwilling to put their resources into digital assets until they know they can be placed somewhere safe. Now, under the SEC rules and the statutes governing investment advisors, there is already an answer. The statute provides that assets may be held with entities that are known as qualified custodians. And there's a statutory list of defined qualified custodians, and on that list is an entity known as a bank, and through further definitional references, a bank is defined as a state-registered and chartered trust company that is supervised by a state regulatory entity. So a state-chartered trust company that is supervised can be a qualified custodian under the statute for the purposes of the Investment Advisors Act. That's great. It reaches a certain area. People are in the industries are already focused on that and working towards creating that infrastructure. But definitions vary. And under the Securities Act, broker-dealers must custody their clients' assets at a secure security location. They have to be at a control location, is what the statute refers to. And it likewise lists a whole number of definitions of acceptable control locations that broker-dealers may place their customers' digital assets for safekeeping. State-chartered trust companies are not in those definitions. Short reason is they're not FDIC insured, they're non-depository, and both under the rules and the statutory language, it really boils down to being whether you're FDIC insured. However, there's a catch-all provision that says the SEC in its discretion can approve an entity to be a control location for the purposes of custodying assets. There's a debate growing. If the Investment Advisors Act considers state-chartered institutions, trust companies, to be sufficiently secure to custody assets for those clients and purchasers of digital assets, isn't there a good argument that they could likewise serve that purpose for broker-dealers? And the reason I think that this is an area where states and federal regulators can work together to advance the growth of the market is largely because the large institutions that would qualify as control locations for broker-dealer purposes have been very hesitant to enter this marketplace. They're taking a watch-and-see approach. They're really, while some have offered and are making noises about offering custody for Bitcoin, no one has really spoken about offering custody for digital security tokens. So there's an opportunity there, I think, for state and federal regulators to work together to find a place that would allow for this incremental growth to occur and for the infrastructure in the market to mature. And with that, I would just say that my sources tell me the SEC actually may be on the verge of issuing some no-action letters with regard to custody. So let's stay tuned and see what those may be. It may change the equation significantly, but it certainly will not change the level of interest. Thanks very much.
All right, well, good. Well, I think you got a very comprehensive overview of the regulatory landscape in this space, with a deep dive on the securities laws and a broad look at a variety of regulatory structures that apply to this area. So a couple of questions, maybe to kind of draw out a couple of points. And Scott, maybe if I could ask you first, you talked about in the Hinman speech this concept, which I'll shorthand as attenuation, that somehow something can start as a security, no longer be a security. Hinman also introduced this. He delineated between something that is a security versus something that's an investment contract, and in fact said that the orange groves in Howey were just oranges; they weren't securities. So how do you distinguish a token that is in fact a security from maybe a token that would be characterized as an investment contract and thus subject to some of this kind of attenuation?
Yeah, so I think it's going to depend on what the total package is. And I think that's the lesson from all of these is you can't just focus in on one element. You can't just focus in on the parts of it that make it look more like one thing and less like another, or vice versa. What you really have to do is you have to look at the totality of what the package is and consider what the reasonable expectations of investors are. Are they buying this thing because they want to use it to consume it? Or are they buying it because they want to hold it for some future appreciation in value? Or are they buying it because they hope that it's liquid and they can immediately resell it and make a profit? And I think when you sort of start focusing in more on those issues, these questions don't get completely easy, but they get a little bit easier.
So, Danny, when you described all of these different regulatory regimes, you made an interesting point, which is that these crypto assets were being defined as much by the regulatory reach of the different agencies as they were by their actual market functionality or action. And so in fact, when we talk about these different regulatory regimes, a token could simultaneously be a currency, a security, a commodity, and property. Of course, the IRS characterizes the tokens as property for the purpose of taxation. How much of a challenge do you think that is, and how do you foresee that being resolved over time?
It's a challenge that has some historical precedent. There have been overlapping jurisdictions by regulatory agencies over financial products for quite a while. It has never been something that the industry sector appreciates or would like to have become more complicated. And that's, I think, what we're seeing at the moment. We're going through a period of kind of exponential complication in the application of different regulations. My visceral sense is that we will experience a decrease really of it for fear that different regulators' wings will be clipped. And by that I mean once certain regulators that have preemptive powers really fully occupy the field and have comprehensively addressed many of the issues that are being addressed piecemeal now because This is something that is not conceived of in any of these early 20th century statutes. I think you're going to see, for example, state regulators pull back from some of their assertiveness. The whole question of whether you need a bit license to deliver digital security into the state of New York. It's an interesting question. Legally, there are arguments on both sides regarding the application of the statute. I would say, however, that when there is a full-blown and mature infrastructure, that it falls under the federal rubric of securities regulation, that states will take the same position that they have traditionally with regard to money transmission governance and ordinary ordinary and commonplace securities, and that is essentially a hands-off. However, it may be, and this is the flip side of the coin, it may be, for example, when talking about the role the OCC bank, if it moved forward, may play. The concern there is, is this bank going to regulate entities that deal on national level transfers or transactions and whatnot, or is it going to be the type of bank that targets its activities towards local populations like mortgages and mortgage servicing, something that states have traditionally been far more effective and concerned in regulating. And at that point, again, I hope an equilibrium will bring to bear based upon the activity that is being regulated, again, rather than the technology.
Right. So it's very interesting. It suggests potentially that the bit license could end up being, its own singular experience in the regulatory evolution, as opposed to a harbinger of things to come. Do you think that the bit license experience, number one, is encouraging other states to look at a similar level of regulation? I do. You do? Yes, I do.
There is actually. There has been an effort by academics and state law regulators to put forward a model law in virtual currency businesses and regulating virtual currency businesses. It's under consideration, I think, in 2 states. It may have been adopted by 1. It's a bit of a hybrid between the bit license and the traditional money transmission license. It takes into account many of the concerns that the bit license tried to take into account. So if this takes off, or something like it takes off, you will have a more common scheme for industry operatives to work with. I think that the New York experience, which was a bumpy one in the beginning because they were not issuing licenses quickly enough, and there was a bottleneck, and people became very frustrated, and New York was such a central financial center, but at the same time such a problem that people thought very poorly of it. The licenses are coming much more quickly now, and I think other states are going to, as I was saying, take into consideration the volatility, the kind of cybersecurity, the kind of other concerns that the bit license embraced.
And how do you see, perhaps contrasting with some of the other developments that we see at the state level? So, for example, in Wyoming, the first state to actually, the first U.S. jurisdiction to actually recognize something called a utility token, and distinguishing it from a security or an investment contract. How would you characterize what you see as kind of from the suite of bills that were passed by the Wyoming legislature?
I applaud their innovation. It's one of the 50 laboratories, and it's interesting. I just think, again, once that is hashed out in some kind of solid and informed way on the federal level, although it may have unique application in Wyoming, and I'm not familiar enough with the jurisdiction to know how that could work, but once it's hashed out on the federal level, that I think is ultimately going to be governing the national marketplace.
So Scott, you talked about kind of some of the different types of tokens from a securities law perspective, and pointed at the SEC, in essence, pointing at the Dow token as this is a security. It bears the hallmarks of a security, conveys a rights of a similar type, profit rights, voting rights. The SEC has now, kind of in a couple of forums, including the Hinman speech, said that they don't view Bitcoin as a utility, as a security. It's mined out, it's used as a currency. It has that that use to it and is fully decentralized. There's no governance body. Ethereum is really it's the question of, there are a number of different, just as Ethereum grew from Bitcoin, there are a number of different platforms that mimicked the Ethereum model, mimicking its governance structure, mimicking its purpose in terms of reprogramming the basic blockchain technology to optimize it for some specific purpose, and potentially meeting those same criteria that Hyman articulated of decentralization and utility. How would you see the process working in terms of trying to distinguish amongst these platforms, or do you think that Ethereum is kind of destined to be a category of one?
Yeah, that's a great question, because over time we may see more that go that truly decentralized route. I mean, I think the difficulty is on day one or even day 100, when you're still sort of in startup mode. There's some governing body, there's promoters, there's people that are trying to build this business, and they stand in the shoes to benefit from the investments that come in. So I think as long as that exists, it's going to be difficult to defeat Howey. Now, we saw what happened in DAO. They tried to circumvent that by decentralizing the governance structure, but yet there was still an entity there that kind of benefited from the investment. I mean, I think what's happened with both Bitcoin and Ether is that they truly are kind of these altruistic networks. There's no, other than the people who are holding the instruments or buying and selling them, there's no third party that's benefiting by that transaction. So that's a distinguishing factor. You know, if I had a client that came to me and said, look, we feel like we're more in the Ether Bitcoin box than we are the DAO box, can we just forget about the SEC? I think I'd be very hesitant to advise them to do that. You know, I think because it is such a rare set of circumstances. You know, one of the things the SEC has tried to do, and I've had mixed success interacting with the staff on this. Some are more open to conversation than others. But one of the themes to the speeches is, if you think it's a close call, come and talk to us. And there is a no action process where you can get relief, at least from the staff. Now, that doesn't bind private plaintiffs or the states, but at least it's helpful, and it knows that the SEC enforcement mechanism won't come after you. You know, historically, the SEC staff has not granted a lot of no action letters in terms of whether something's a security or not. But there are some isolated precedents for it, and I think this is an area where they might be willing to be more forthcoming with that kind of information, because there is this level of market uncertainty.
So you noted that a lot of these companies are in startup mode, and that in a certain way, the capital formations being used, that the tokens are being used for, is almost replacing the friends and family round or the seed round. And then in many instances, a lot of these platforms are using exemptions. How would a platform use an exemption to do capital formation with a token?
Yeah, so people have kind of experimented with different ways of doing that. Now, one way is the SEC under the Jobs Act has something called regulation crowdfunding, which allows widespread retail participation. The downside is you can only raise, well, it used to be $1 million, and it's been inflation adjusted now to be $1,070,000 or something like that, but it's still not a lot of money if it's around $1 million. And two, to raise that kind of money, you have to have audited financial statements and prepare almost the same kind of disclosure documents that a public company would. So that significantly limits its application. Another way you might be able to do it is to rely on the Regulation D exemption. You can market to a broad group of people now under the Jobs Act, again, under something called Rule 506C, but you can only accept subscriptions from accredited investors. You know, that's problematic because these are people that have a certain minimum net worth, and what you get through that offering is what's called a restricted security, which means you can't really trade it in secondary trading for the most part for up to a year. So that's a downside. Another exemption people have been looking at is Regulation A. That's also was amended by the Jobs Act. That gives you up to $50 million, and you can do it in a quasi-public offering and accept subscriptions from retail investors. The downside there is you have to go through a registration process with the SEC, and to date the SEC has not, staff has not approved a single Regulation A offering involving tokens. Anecdotally, I know of lots of examples of tokens that are in registration, but they're just kind of stuck there. I think that bottleneck is going to have to clear up soon, because it's sort of disingenuous for the agency to say, well, let's treat these as securities, and if you don't have a good exemption, you better come register them. We'll go through a registration-like process, but then not let people actually sell those securities. So that's got to go. Another possibility is to do a full-blown registered offering without one of the sort of gimmicky or not so gimmicky exemptions. There are a handful of parties that have tried that. Again, they haven't gotten their way through. There we're talking about full-blown public registration like any other IPO company would, and there are some significant costs associated with that. So unless you're planning to raise a lot of money, it's the opportunity cost for hiring lawyers and accountants and possibly bankers, is just not there for the typical startup business. So it's a theoretical possibility. Another workaround that's been used to some degree is a simple agreement for a future token, a SAFT, which is, we could do a whole 3 hours on that. It's meant to mimic something called a simple agreement for future equity, which is basically give us the money now under some very, very loose terms, and when we actually issue the security in the future or the token in the future, then you'll get whatever that is. There's a whole debate as to whether that works under the securities laws and the commodities laws. But assuming that it does, one theory is you could sell the SAFT now. The holders would hold it for a year, which is the Rule 144 holding period. And at the end of that year, they would get the token and it would be freely tradable. It's more of a hypothetical right now. I don't know of anyone that's tried that. Another law firm just wrote a kind of a client alert white paper on that idea. I think it's a good idea, but it hasn't come to pass yet. So those are all the different things people are talking about. Now, of course, none of them are as satisfactory as just read our white paper and send us your check tomorrow, or send us your Ether or Bitcoin or whatever digital asset is accepted in lieu of fiat payment. But I think people that are serious about compliance are having to look at these. And of course, the states have an interest in all of this too, and they can regulate these things unless they're preempted, which they only would be preempted under a full-blown public offering, a Regulation D, Rule 506 offering, although there's limited preemption, or certain types of Regulation A offerings. But even if it's the offering rules are preempted, the states still have anti-fraud authority, and that's pretty powerful. New York, of course, has the Martin Act, which doesn't have any knowledge requirement. It's a strict liability regime. So I think that's one more reason why folks getting into this, even if you go through the registration process, you have to be honest and truthful and full and fair in your disclosure, which perhaps has been an issue with some of the white papers in the past.
A question from an online viewer. You talked a little bit about private litigation. Danny has written for us for our blog on the Tezos Securities litigation case. There's the Ripple. What about state UDAP authority, unfair, deceptive acts and practices, sort of consumer protection type lawsuits? Is that something that you see as coming down the pike as a threat?
I haven't seen as many sort of attorneys general type actions under those in states that have a private right of action. Usually those kinds of things are pled, in addition to the securities fraud claims, because it's sort of the scattershot approach of, well, if it's not a security, we at least want to have some other general anti-fraud statute that we can rely on, and if it's a deceptive trade practices type statute or something else, then we'll rely on that. Sometimes it's just a common law fraud claim. And again, it's interesting because you normally don't see this kind of litigation against startup companies. Their usual investors are venture capital firms or other high net worth individuals that just as soon not publicize the fact that they lost money on a deal, or if they're professional investors, that comes with the territory. But when you do these offerings to hundreds or thousands of retail mom and pop type investors, some of them are going to be dissatisfied, and rightfully so with some of these instruments.
If I just might add to that, there are some storm clouds on the horizon in that regard. Last month, I think it was, the New York State Attorney General put out a report having investigated the nature of operations of virtual currency exchanges and whether or not there were appropriate protections in place against, fraudulent activity in there. That may be a warning that there is an interest growing there, and under the Martin Act, which may actually be viewed more broadly than federal securities law in terms of identifying digital tokens as a possible security that falls within its grasp. The other thing I would note is that so many of the ICOs that have taken place over the past year or so have been overseas, and it may well be really difficult to assert jurisdiction for a consumer kind of fraud allegation, particularly on behalf of private plaintiffs, given the physical distance.
Yeah, so to talk a bit about that private litigation, you mentioned that there's typically a federal securities law violation alleged, and then either federal or state law, either securities violations or fraud claims. On the one hand, it would seem that if there is evidence of fraud, that would be the easier ground for a court to find on. So on the one hand, do you see many of these cases being potentially ruled on from the fraud side? On the flip side, what is the SEC's level of concern that the courts begin to interpret how crypto assets should be addressed under Howey and its progeny, without the SEC being involved?
Yeah, so, from a private complaint type situation, some of the lawsuits have alleged fraud. Others have not. Others have just alleged a private right that you offered me an unregistered security, and that's not what, and you didn't register it. And so the benefit to a private plaintiff is most states provide for a rescission remedy. And most states require not only that you get your original investment back, but that you get money back at some imputed rate of interest. And some of those statutes are never, adjusted. Some states, like Texas, readjust their rate periodically. Other states don't, and they might have a statutory rate of return that was set 10, 20, 30 years ago. You get 8% on your money.
It's the best investment you could possibly make.
Yeah, that's right. So that's the play in some cases, is just to ask for a rescission remedy and damages plus interest. There's usually a right to attorney's fees as well, which makes our colleagues on the plaintiff side interested in these cases. In terms of where some of the states are going, we are seeing, the heavy enforcement by states like Texas and Massachusetts already. NASA has a sweep that you alluded to, I think it's Project Crypto Sweep or something like that, where they've brought dozens of cases around the country. Again, the different regimes vary. I mean, one of the interesting things the states can do is they can generally go and commence a summary cease and desist proceeding and immediately shut down an offering on their own without having to go before a judge of any kind, which is generally not a power that the SEC has. Something that the states also can do is sort of an interesting quirk of inside baseball at the SEC. For decades, the SEC's General Counsel's Office has interpreted its statutes as prohibiting undercover operations by SEC personnel. Now, sometimes the SEC staff work in conjunction with their criminal counterparts, at the FBI or elsewhere, who are running undercover sting-type operations, but SEC enforcement attorneys cannot do that. Many of the states don't have that same kind of limitation. Pennsylvania, for example, is a state where the blue sky regulator can do undercover sort of secret shopper kind of investigations. And the SEC staff's aware of that, and sometimes they refer things out to the states that they can't quite get using their limited resources, but the states can. So to your point, I think there is a much greater level of coordination already beginning between the SEC and the states, and likewise between the SEC and the CFTC, even though they've both asserted the same jurisdiction over these instruments. I sometimes call it sort of quantum physics of regulation, because usually it's a binary choice. It's either security or a commodity. It's not both. With crypto, though, it can be both. But the SEC is tending to focus on sort of one element of enforcement, and the CFTC is starting to focus on another, and there's not a whole lot of overlap in the cases they brought. Although there have been some joint cases they brought. They brought a joint case recently for an instrument that violated both the SEC's statutes and the Commodity Exchange Act. So that's been interesting to see as well.
There's an ongoing criminal litigation, criminal matter in the Eastern District of New York, where the defendants challenged the application of Howey on a whole host of both statutory and constitutional grounds. It gave folks some concern that these issues were being teed up in a criminal prosecution, particularly with a defendant who, by the time he had essentially defrauded many, many people and had squandered his funds, was being represented by the federal defenders, excellent group of attorneys, but folks were concerned that the nuances of the interpretation and the impact it could have going forward in the civil arena could be quite significant. The SEC submitted briefs as amicus. The Justice Department was involved, and the judge did a very cagey judge-like thing. He kicked the ball, down the field and said, "I'm going to sustain the indictment. You prove the Howey test at trial, and we'll see where it all shakes out."
Yeah.
So nothing really has developed on the judicial level yet, but there is that concern as well.
Yeah, and to kind of answer your last question, Al, I mean, there has been some litigation in the civil context as well. And so far, both on the SEC side and the CFTC side, where the SEC has alleged that a security exists, the defendant will say, no, it's not a security, you have no jurisdiction. There's been a handful of reported cases now where the courts, the federal courts, have agreed, no, these do at least pass the Howey test at kind of the preliminary stage. And likewise, we didn't go into the CFTC side a whole lot, but there have been some enforcement cases there where the defendant has again asserted, well, this isn't really a commodity, you have no jurisdiction, and likewise the courts have not so far been very sympathetic to that. But the SEC monitors these things. They submit amicus briefs. Sometimes they're invited to, sometimes they're not, but they have a very active appellate group that follows these kinds of things, and the trial unit, of course, follows it, and they, as need be, they'll weigh in.
Well, great. Well, as was noted, I think we could go on talking about these issues for hours, but that's about all the time that we have for this program. So let me just say thank you to both of our panelists. I think an excellent discussion and exposition of these issues, and hopefully it was useful to the viewers.
Thank you, Alan.